I've been in the sector for a while. Believe it or not, I've been in the charity sector for over 20 years now. On mergers, I was first involved with one in 2009 when Help the Aged merged with Age Concern. And that was a UK-wide merger, and everybody thought, this is going to be the start. We're going to start seeing mergers, charities are going to get it, there's going to be a real revolution here. And we thought, lots of work for us, no bones about it. And what happened? Nothing. 2008, that had been and gone. That was possibly the catalyst. And during the 20 years that I've been involved in the sector, there's been various pinch points like that as people in the sector, advisors in the sector, we have thought, this is going to be it. This is going to be the time when we start seeing this collaboration, this mergers. For me, 24,500 charities in Scotland is too many. And for example, this week, I've had 3 people come to me to speak about, we want to set up a charity. Now, I'm old enough and ugly enough and brave enough to say, why? Why do you want to set up a charity? What are you doing that is so different from the charity that's next door? And then listen to them. Very rarely do you manage to convince somebody not to go down the route of setting up a new charity. This slide that I put up just now, we usually put up and say, this is everything that Brodies can do for you. We're a full-service legal firm. Whatever advice you need, we can do it. These are the sort of things, if you're collaborating, going into partnership or merging, that you have to be thinking about. Regulation, pensions, legacies, gifting, all of these things are things that you have to think about when you're starting to go down the route of collaboration or mergers. Top tips, corny as it is, this is taken from things that I have seen over the years, and I have to confess that at this moment in time, we are getting a lot of inquiries from struggling charities. It's usually at that point in time when there is no other option, and the exit in some form or another is coming down the tracks. Do your charitable objects align with those of the organisation that you're considering working with? Yes, you do have charitable objects. They will be in your constitution. I have been standing here, I gave my first charity trustee talk in May 2008, and I'm saying the same things now and getting similar responses. Do you know where your constitution is? Do you know what it is? Let alone what does it say? And that is absolutely vital. And there is something to be said for the constitution and what it says. At many, many times, it can keep you on the right tracks. It grounds you. It brings you back to what you are supposed to be doing. And the reason you have to know what your charitable objects are is you have to ask the why. Why are we about to enter into this collaboration with another organisation, and do our charitable objects match? Are we doing the same things? And that's very, very important. And you always have to bear in mind that there are options. So if it is a marvellous opportunity and it will keep your organisation going, you might have to change your objects, and you can do it. You need the consent of Oscar, but you can do it. Get professional advice early. Well, I would say that, wouldn't I? But it's true. Go and seek professional advice. Don't waste a huge amount of time trying to find out for yourselves. People like me, we do talks for nothing all the time. Not quite all the time. But there's a lot of free information out there. I would be surprised if there wasn't a charity lawyer or a professional advisor in the sector who would not give you an hour of their time at the start to say, that idea that's not a goer, but that one over there is, or have you thought about? And I would suggest that you do that. Costs as well is something to think about. You will have to pay for costs. It's inevitable. In a merger situation, I could stand here and be very grand and say, well, look at that as an investment as opposed to a cost. In a wind down, it is going to be a cost, and it means ultimately less money if you're in a solvent situation for the beneficiaries. And hold your professional advisors to account. Don't be afraid. Ask for estimates. Ask them how much it's going to cost. You will be told, well, this is what our estimate is, our best estimate is, and it is likely that something will crawl out the woodwork. You would be surprised what crawls out the woodwork. Identify your challenges early. Property. Lots of charities are gifted property. There are some weird and wonderful conditions in gifts of property. You might think you can do whatever you want with the property that you are sitting on. The title deeds may well say something different. The lease may well say something different. And sometimes these points at the start drive the direction of travel. It might drive the vehicle that you end up using or the charity that you end up using if the intention is indeed to merge. Pensions used to be a showstopper. It doesn't seem to be the case now. I'm not hearing so many people saying we can't do it because of pensions. The pension deficit challenge, that if you merged, it would kick in and you would have to come up with a sum of cash. That does seem to have gone away. I'm sure it wouldn't have gone away, but it doesn't seem to be the reason that it used to be. Back to the Constitution. Do you actually have the power in the Constitution to do what you want to do? Modern legal vehicles, your Scottish Charitable Incorporated Organisation, the SCIO, companies limited by guarantee, it's likely that you will have a blanket power to do whatever you want to do, which is good. If you're operating under an older trust, you will have specific powers, and you may not have the precise power to do what you want to do, so that will require a little bit of work. But I'm not advocating that you go out and convert to a SCIO. That's a lot of work as well. It's a lot of money, it's a lot of time. So if someone is saying to you the answer to all your prayers is to convert to a SCIO, please think again. Tax. Charities do pay tax. My colleague in corporate tax is forever getting bombarded with last-minute queries on corporate tax and particularly VAT issues from charities. So think very carefully. Chances are it will be a no, but it might be a yes. You do need advice. Close these sort of things down early. Build in time. It's a long journey, and there will be hiccups along the way. We were recently doing a large merger for a social care organisation, and the care inspectorate was involved, and a very well-respected charity. And they'd fixed the date, yes, everything's fine. And then the care inspectorate said, it'll take us easily 6 months to look at these, changing these registrations over for the services. But we're a well-respected organisation. We're going to be saving jobs. We're going to be the beneficiaries. No, 6 months at the earliest. And that required a whole change of plan and the way that the merger was done. If you're a membership organisation and you require the consent of your members, think about that. What does it say? What does your constitution say about AGMs? What does it say about EGMs? Factor that into your timetable. Decision making is difficult. It's the hardest thing that you will do as trustees. And I'll often say to charities when it goes quiet in the room and everybody's scratching their head, if you go back to your charity trustee duties, it can focus your mind. And very broadly, your general charity trustee duties are to act in the interests of the charity. It's what you're proposing. Does it further the charity's objects? And are you taking those decisions free from conflicts of interest? And conflicts of interest remains one of the major issues at charity board level. And I've heard that recently from Oscar. It's still the case. Trustees, do not recognise when they have conflicts of interest, and it's a clear breach of your charity trustee duties if you don't. You act in a manner consistent with your charity's purposes, and that's your charitable purposes, and we've mentioned that before. You act with the appropriate level of care and diligence, and for charity trustees, that is the level of care that is reasonable to expect of an individual looking after the affairs of another individual. And generally, that means you are more careful with the charity's assets than you would be were they your own. There's a very particular conflict of interest, an appointment conflict of interest mentioned in the legislation, which is the last one, and that is if you have people on your board who are appointed by another organisation. So, for example, if you have people on your board that are appointed by the local authority, say, and in those circumstances, if you have a transaction with the council, then those people are in a particular position and they just simply cannot take part in it in any way. Consider what your options are and consider your risks. There's always more than one option, because there's always the do-nothing option, no matter if you know that that's a non-starter. And consider what the risks are around them. And then you take your decision from there. And this very last sentence on the slide is a sentence I particularly like. None of us can see into the future. None of us know how things will turn out. But if you as a body of trustees make a decision within the range of decisions that a reasonable body of trustees would take, then from a regulatory point of view, you will be free from criticism. So you're not taking the wild decision that's out there in the blue yonder, but there'll be a scale of things that you can do, and if you're within that scale, 10 years' time, somebody turns around and say, well, that was the worst decision they could ever have made. How did they possibly manage to do that? If the time when the decision was made, it was reasonable, then you will be fine from a regulatory point of view. The next slide is a step-by-step guide to mergers, which you will be delighted to hear. I'm not going to go through. But it's just to give you an idea of how complex the process is. It's not straightforward. So if you're going to say, oh, let's merge with that charity in a month's time, well, you're going to be working 24/7 plus and still not get there. There's various pinch points along the way. At the start of the conversation, you might want to make it confidential, so a non-disclosure agreement, so that all and sundry doesn't think, oh, well, that charity's come to the end, employees up off working for somebody else, making the situation even worse. You'll hear due diligence mentioned a lot, and due diligence is simply checking the assets of the other charity to make sure that there is nothing in there that would mean that you wouldn't want to merge with them. And that's sometimes the point where, for example, the property challenge comes up that says, you know, the property can't be used for what the new organisation or the merged entity wants to use. And from a cost point of view, the more that you can do of that yourself and have your house in order, the easier it is for somebody else to look at and to take on board and say, you know, this is a good deal. The decision's in there, that's when you apply your charity trustee duties. And if you follow the path through, you eventually get to the winding up. As we've said already, you need Oscar's consent to do that. A headline caught my eye this morning in the charity press, and yesterday David Holdsworth, the Chief Executive of the Charity Commission for England and Wales, was delivering a speech to the Charity Times Annual Conference 2025, and he was broadly suggesting collaboration. And one thing caught my eye, which I think is very, very relevant, and what he said was, no lasting change comes from isolated efforts. Discuss. Thank you.